2009DS. Mr. Caswell is here today after failing to appear before referee Snyder on January 8th, 2024. Bond is currently set at $13,776. This is the 8th bench warrant. He reports that he is self-employed. The last payment made on this account was in September of 2023. That was a $1,500 purge payment after being found in contempt and sentenced to 45 days, I believe it was. Prior to that, the last payment was in June of 2006. Front of the court recommends that a reasonable bond be set in this matter and it be scheduled for hearing on April 3rd, 2024 at 8:45 a.m. before this court.
Thank you. Mr. Caswell, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on April 3rd, 2024 at 8:45 a.m. You will get notice of that in writing. Are you able to post a bond, sir?
No, I'm not.
Okay. Well, you've got a sizable, obviously, an extremely large arrearage in this particular matter. You've had 8 prior show causes in this case. You've had prior finding of contempt, etc. And so what I'm going to do, I am going to reduce your bond in hopes that you could be released pending that hearing. I'm going to set your bond in the amount of $1,500. If you're able to post that, you'd be able to be released. Do you have any questions, sir?
Nope.
Okay, thank you, sir. You're free to go. Have a good day.
Fuck you too. Fuck you too. Fuck you too.
Good morning to both of you in this matter. Mr. Hanker, the court notes, and I see that you have someone with you, and who is that individual?
That is Sean, my little brother.
Okay, and Sean, why are you present with?
I am Jeffrey's guardian and conservator.
Okay, that's what I was wondering. I didn't know, and I didn't have anything in the file to show who it was. So, again, your first name, sir? Sean?
My first name is Sean.
Okay, thank you.
S-E-A-N.
Okay, this is the time and place set for the trial in this particular matter. I guess I'll ask Mr. Hanker, and I guess I'll refer to both. Are you ready to proceed, sir?
Yes.
And Ms. Gilman, are you ready to proceed?
Yes, Your Honor.
Okay. Mr. Hanker, you have an opportunity at this point to make an opening statement if you wish to do so, or you can waive your opening statement. What do you wish to do, sir?
No, really, I just want my boy more than just a weekend at a time. So I just want more time on the son.
Okay, well, let me clarify then, because obviously we have, with that in mind, and I do note that you've been involved in a pretty serious auto accident, so I understand that from the past proceedings. But when originally in the complaint you had sought joint legal and joint physical custody, and in the answer, the defendant sought sole custody. So with what you're saying, it sounds like you're seeking parenting time in contrast to custody. Is that correct?
Yes.
Okay. Okay. And Ms. Gilman, are you aware of that now that that the plaintiff has again withdrew the request for joint legal and physical custody?
Yes, Your Honor.
Okay. Just for the information, because the court wasn't aware until just now. How did you get that information?
He's always said that he just wanted more time. When we did mediation, they said that they wanted 50-50 week on, week off, and that's why I thought we were here. So.
Okay. So, well, the reason I ask this, it does make a difference in the case as we proceed, because the way as we proceed, issues concerning parenting time are different than issues concerning custody. So I just wanted to be aware of that so that we know why we're proceeding and we don't take a substantial amount of time in the case that we don't need to. So, Ms. Gilman, do you wish to make an opening statement, or you can reserve your opening statement, or you can waive your opening statement?
I would prefer to say a statement.
Okay, go ahead.
First and foremost, I want what is in the best interest of Barrett. I always wanted Mr. Hanker included, and I just want to make sure that he's able to retain his daycare because that's paid for by DHS.
Okay. Let me, and I guess I don't want to short circuit this, et cetera, but I want to see, because we're not obviously going after custody anymore. Mr. Hanker, what are you looking for as it states for when you say more time? What are you looking for?
I'm just really looking for like a week on, week off type of deal for
Okay.
having him. Instead of just more time than just a weekend, actually. That's the biggest thing.
Okay. Well, with that, then it looks like we're going to have to proceed. So anything else, Ms. Gilman, in your opening statement?
No, sir.
Okay. Then, Mr. Hanker, you have a right now at this point to present your case. I will tell the parties in this particular matter that as we start in this case, each of you will have multiple opportunities to speak. So I'll say, don't interrupt each other or any potential witnesses we have, and don't interrupt me as well. Again, you'll be given adequate opportunity to speak. You'll have opportunity to respond as well. So don't simply, and during the time that someone is else is speaking, please don't interject or make comments or make any other actions in this matter. This is a court proceeding, even though we're doing it virtually. And if you engage in offensive conduct or interrupt the court proceedings, you could be held in contempt of court and go to jail. So I just want to make you aware of that. I also want you to know that these kind of proceedings sometimes get emotional. If that happens and you need to take a moment to compose yourself, you can always ask the court for a brief recess where you can have 5-10 minutes to, again, calm down, and then we'll come back and continue. So at this point, with that, Mr. Hanker, you can you can offer testimony at this point if you wish to do so. The court will note, because Sean is your guardian, the court would again allow him to testify in this matter, notwithstanding the fact that you didn't disclose him as a potential witness, but because he is the guardian in that legal capacity, the court would let him testify. So to the plaintiff, who do you wish to have as your first witness?
I think I'll actually have the little brother. Actually,
Okay, sir, you can proceed and tell me what you would like me to be aware of.
Well, in this whole thing, basically what we're looking for, what Jeffrey is looking for, in this whole custody case is we're looking for a 7-on-7. So Mrs. Gilman would have Barrett 7 days out of the 14 days, and then we would have Barrett 7 out of the 14 too. So we're looking for a basically a 50-50.
Well, that's why I initially asked in this case when your brother was given his opening statement, is that if you're doing a 50-50, that's more like joint custody as opposed to parenting time.
Yes.
Okay, so that's what you're asking. Tell me why the court should do that.
Well, I just think in the best interest for Barrett that he should be able to see both of his parents 50-50, equal time and everything for his best interest in his future.
Okay. Obviously, I do note that your brother had some very substantial injuries in, during the course of this proceeding after the accident. Would you kind of highlight, if you would, or explain what those are so the court is well aware of that?
Yes. He has short-term memory loss still, and some long-term memory. He also has a vision problem in his left eye, and he cannot see out of his left eye that well. But he's fully functional out of his right eye from the accident.
The court notes that you have been appointed by the probate court as his guardian in this particular matter. And as a result of that proceeding, you had to demonstrate by clear and convincing evidence that he was a legally incapacitated individual, and it was necessary to have an appointment to be able to provide him with continued care and supervision in this matter. So what type of care are you providing for your brother at this time?
I am doing the medical, placement, and legal for him.
Okay. Well, that doesn't tell me much. I want to know specifically when you say I'm doing medical, what does that mean?
Basically taking him to his doctor's appointments, scheduling his doctor's appointments, and all that, because he is not able to drive. The eye doctor he doesn't have a license.
Okay. Is your brother, if you were not there to provide the assistance to him, obviously he couldn't drive, but is he able to schedule his own doctor's appointments?
Yes, pretty much. I mean, we've been letting him do a few things, here and there. When they call him, he'd schedule them here and there, but mostly I do it right on my phone because it comes through my email when we schedule appointments.
What other things do you do besides, as you said, the medical and the legal issues?
Basically, I also have placement. So like he's living with us because he doesn't currently have his house. His house is up for sale. So basically, I have control over where he lives and all that.
If in fact you were not doing the things that you're doing, and he was on his own, let's say he had to find a place to live, would he be able to do all the things you need to do to find and maintain a place to live, such as he'd have to find an apartment or a home, he'd have to, again, be able to, I guess you say, connect with his utilities, that he'd have to pay deposits, he'd have to pay his utilities, et cetera. Is he able to do that?
I think he would be able to. I mean, it'd be a little difficult, but I think he'd be able to do it.
You said that he has short-term and some long-term memory loss. If in fact he was at the doctor for something, he was at an appointment, and the doctor was trying to discuss some procedure or something of that nature, and going through that, do you feel that would he have the capacity to make an informed decision about his care if in fact you weren't there to assist?
Yes, I believe he would be able to, because when we go to the doctors, I mean, I let him answer all the questions of the doctor, and then I'm just there basically. I'm observing, and then if the doctor has any questions, they ask me. But for most of the part, Jeffrey, I let him answer all the questions and all that.
Okay. What else would you like me to be aware of, sir?
I don't think there's anything else, just except that.
Okay. Ms. Gilman, do you have any questions of plaintiff?
No.
Ma'am, you have sought sole custody in this matter, and the court will note that the plaintiff has both through the plaintiff and the guardian have stated that they're not proceeding with a claim for custody, for joint custody, but they want effect equal parenting time. Tell me why that shouldn't happen.
Well, I have to work, so I have Barrett in daycare for that purpose, so I can provide for him as well as his social development, and his speech therapist meets him at daycare on the regular. I've been the one scheduling Barrett's appointments from the time of birth, as well as taking off time or just going to the appointments as needed, and making sure that he's on a routine for everyday life, as far as making sure in the mornings and at night we brush teeth, bath time, his sleep schedule due to being dropped off at daycare by 7:30. It's just his normal routine. And I'm not saying that Mr. Hinker and Sean are incapable of doing those things. I just have fear that they won't have the time, or since Mr. Hinker is relying on Sean for travel, that means that responsibility falls on Sean as well, to make sure that Barrett gets to daycare and to and from, probably, which hasn't been an issue because they do pick up Barrett every other weekend from daycare. Just to make sure that I can maintain daycare, because without daycare, I can't work as many hours as I'm working to provide for him. Daycare is paid by DHS, as I stated before, and they have a required amount of time that Barrett has to be there for them to pay for the full daycare cost.
Okay. Tell me, if you would, tell me what the situation was, your living situation with the child since the child was born.
When the child was born, I lived with Mr. Hinker as we were in a relationship. And then after his first birthday, I had decided that it wasn't working between me and Mr. Hinker. And I moved into an apartment, a 1-bedroom apartment, and have been there since.
Okay. Tell me, you said after the first birthday, when did you actually separate and move out?
Towards the end of July. I can't remember the exact date.
Of 2023?
Yes, sir.
And tell me what's happened since that time with your son.
We've been going to daycare. I've been going to work every other weekend, or sometimes 2 weekends in a row when Mr. Hinker asks. Barrett goes with them. And on occasions when it's like something that could be a good memory for both parents, I do invite Mr. Hinker.
Let's say since July, you said the time that Mr. Hinker has had your son, it's been, as you said, alternating weekends or sometimes 2 weekends in a row.
Yes, sir.
And then at special events or special dates or stuff?
I tried to include him as best as well. For instance, Christmas Eve, I had dropped off Barrett. Barrett got to spend Christmas morning with Mr. Hinker and Sean. And then towards the evening, I had picked up Barrett and spent some time on Christmas with him, and then dropped him back off to Mr. Hinker.
Explain to me, if you would, what is your relationship with your son?
I'm his mother.
Well, I understand. I'm saying you're kind of your interaction and things of that nature.
After daycare, when I'm able to pick him up, if I get out of work early enough, if not, my partner picks him up, and my full attention is him. I make sure that my partner knows to make sure that he eats when he gets out of daycare. And then when I come home, I normally cook dinner, interact with my son by playing with him or reading books. We're working on his speech, so it's like conversations with him, trying to get him to repeat words. Go to the park on weekends.
So, tell me, you say you work on speech. What's the reason for that?
When Barrett was born, he had a tongue tie, and we just had his first dental appointment and found out that he has a lip tie, and both of those could cause issues with speech.
And has that, again, you said there's therapy, but have you been doing, was there other medical procedures that needed to be done?
Yes, he has had his lip tie or his tongue tie reversed at 2 weeks. And then I've informed Mr. Hanker that in May, he has a procedure to get his lip tie corrected, or more or less I can't think of the word. It may get corrected that day, or it just might be a consult, but I have informed him the day and the time of that. I tell him anything that's going on medically, I do inform Mr. Hanker and let him know as well.
How would you characterize your relationship with your son?
Challenging at times, but the best part of my life is being a mother. He's my world. I was very hurt when Mr. Hanker first filed, because at that time, before my work schedule had changed, he was picking up Barrett from daycare and spending time with him. And it wasn't until I found out the requirements of him having to be at the daycare for so many hours for DHS to pay for it that my work schedule also changed in the mix, which allowed me to have Barrett at daycare until 4:30, which is like, he could probably leave at 4, but I'm allowed to have him there up until 5. 5 is the latest that he can be picked up. And Mr. Hanker and Sean and the other party in the home are on the pickup list at daycare.
What types of things besides the therapy do you do as far as working with the child educationally? Do you do, educational books, programs? What do you do?
Mainly it's just books and some TV time with the education, like Bluey, really educational wise, other than being at daycare and learning there. We color, read the books at home. That's as far as it's gotten so far. And then speech therapy from early on comes to daycare with him and does it with him, because I'm unable to do or make home visits sometimes. We've had 1 home visit so far.
You said you work, ma'am. Where do you work at?
I work at Irwin Avenue Animal Hospital as a receptionist.
And I take it from what you said, you work full time?
Yes, sir.
And what is your, how much do you make per hour?
I make $18 an hour.
Do you have any costs associated with it? Do you have any medical insurance that you pay for?
No, that is provided through DHS for Barrett.
So you have Medicaid then?
Yes, sir.
And do you have any mental or physical limitations that would impact your caring for your son?
No, sir.
How has your son done with, again, your schedule, routine? How does he respond to that?
He responds to it pretty well. Normally he beats me up beats my alarm by a couple of minutes waking up in the morning. And when I ask him if he's ready to go to bed around 7:30, 8 o'clock, he will nod his head and walk right into the bedroom.
Since you separated in this particular matter back in July, approximately, has the plaintiff provided you with any financial assistance?
He has bought in diapers once. The last time I had mentioned that Barrett needed anything, he did buy those things for his home. We do share the pair of shoes that he did purchase, and I told him that if we could agree upon it, since he bought this pair this time, that I would go ahead and get the pair next time.
But other than that, as you said, diapers once and some other things for the house and the shoes, anything else?
No, Your Honor.
And where you're living, tell me how stable is that?
That is stable. I'm actually currently getting ready to move to Albion in a house that was just purchased.
I didn't catch that. What was that?
It's stable. I'm actually currently getting ready to move to Albion into a home with 3 bedrooms.
And is that a home that you're going to be renting or you're going to be buying or what?
My partner is buying.
Tell me about your relationship with this other individual. Has there been any plans to marry or not, or what's happening?
Marriage has been asked, but I said that it's too new of a relationship to think about marriage right now. My main focus is Barrett. I enjoy being in my relationship. It's just Barrett comes first. And he's actually been helping me quite a lot with Barrett, and Barrett has grown attached to him and listens, and he helps out a bunch.
Okay. Anything else that you would like me to be aware of, ma'am?
No, Your Honor.
Okay, thank you. Sean, is there any questions that you have of the defendant?
I don't think so.
Sean, I do have some follow-up questions after talking to Ms. Gilman, getting that. Does the plaintiff have any income coming in or anything of that nature?
Currently right now he has his State Farm unemployment, basically his wage loss through State Farm every month. And then he also has short-term disability through his employer until the end of the month. And then he gets switched to long-term disability through them.
Okay. And the amount of the unemployment through State Farm, how much is that?
It's been varying. It's been around $3,400 a month for his bills and all that.
Okay. And the disability, how much is that per month?
It's like $360 a week, so be around $1,300, $1,400 a month for them.
Well, I think actually $1,548 a month, because it's be multiplied by 4.3 weeks. And I think you highlighted his medical condition as well. How long do you anticipate that the guardianship will continue?
We went back to court on the 1st of February, and I have it for their thinking about another year is what we planned.
Okay, so one more year.
Yeah. And that was through the Washtenaw County courts.
Oh, okay.
And the file has been transferred to Calhoun County. I don't have a file through them yet.
Again, anything else that you'd like to tell me, sir?
I don't think so.
Is what Ms. Gilman stated as far as the parenting time that plaintiff has had, is that accurate, that it's been pretty much alternating weekends, but sometimes 2 weekends in a row? And,
Yes.
Then some other times like Christmas and things of that nature?
Yes, that is correct.
Sean, is there anything else that you'd like to present to the court before we conclude?
I don't think so. No, I mean, not anything that's already been covered.
Ms. Gilman, is there anything else that you would like to provide?
No, Your Honor.
With that, then I'll let Sean, if you wish, you can make a closing argument at this time if you wish to do so.
No, I don't even know what to say. I don't really have a closing argument.
Okay, that's fine. You don't have to. I just asked. Ms. Gilman, is there any closing argument you'd like to make?
No, Your Honor.
Okay, thank you. Well, that will conclude the proofs in this matter. The court now will, in fact, go through and give a ruling in deciding custody. And I'm saying custody because notwithstanding the statements on opening that the plaintiff was not seeking joint legal or joint physical custody, obviously based upon the parenting time, it does appear that, so the court is going to address that just to make sure that, again, the court addresses everything that I am required to address in this particular matter. The court will note that the court is required to consider, pursuant to Michigan Compiled Law 722.26A, whether an award of joint custody is appropriate. And as a result, the court will consider that in this particular matter. There's different things because of joint custody is different than, or joint legal custody is different than joint physical custody. Obviously, physical custody is where the parties have some arrangement whereby they would share the custody of the child. It could be is something like alternating weekends or something of that nature, up to even as stated, the alternating weeks. Joint legal custody, the court, in considering that, the court has to consider whether the parties or the parents are able to cooperate on child rearing issues, and it's not necessarily that they get along in doing so. But in every case of custody, the court has to first determine whether an established custodial environment exists. An established custodial environment exists if over an appreciable time, the child naturally looks to the custodian in that environment for guidance, discipline, necessities of life, and parental comfort. The statute provides that the age of the child, the physical environment, and the inclination of the custodian and the child as to the permanency of the relationship shall be considered. In this particular matter, the court will note that the parties were together until approximately July of 2023. And at that time, the parties separated, the defendant having moved out and left the plaintiff's home. Since that time, the plaintiff has, other than the times when he was hospitalized or things of that nature, which the court will take notice of because the court had been apprised back in November of 2023, as well as October, that the plaintiff had not appeared at some hearings that the court had because he was hospitalized at that time. And court recalls that, in fact, at one point, I believe that the court had been informed that he was in a coma. And so court notes that he had some pretty serious injuries at that particular time. But notwithstanding that, he, in fact, had alternating weekend parenting time and some additional parenting time. As stated by Sean Anker today, he had testified the plaintiff has short-term memory loss. He has some long-term memory loss, and he's lost vision in his left eye. And So the court will note that at least since July of 2023 through the current date, so we're talking approximately 9 months, the child has been solely in the care and custody of the defendant. That in this case, it does appear that, again, as she states, she has a good relationship with her son. Son is her whole world, as she states. She's even, notwithstanding the fact that she'd been asked to get married, that she has not agreed to that because she feels that it's too recent and she wanted to, in fact, devote her time to her son. And it does appear as a result that other than the weekends, et cetera, that the child has looked to her for guidance and the necessities of life and parental comfort. As a result, the court will find that the defendant has an established custodial environment with the minor child. That's important because when there's an established custodial environment, the court cannot change the established custodial environment unless there's presented clear and convincing evidence that it's in the best interest of the minor child. Clear and convincing evidence is evidence which would produce in the mind of the trier of fact a firm belief or conviction as to the truth of the allegations to be established. Evidence so clear, direct, and weighty and convincing as to enable the fact finder to come to a clear conviction without hesitancy of the truth of the precise facts in issue and dispute. In this particular matter, to determine the best interest, the court has to look at the best interest of the child test as delineated under Michigan Compiled Laws 722.20. First factor is the love, affection, other emotional ties existing between the parties involved and the child. In this case, the defendant has testified about the relationship she has with the child. She has testified about, again, that she does a substantial amount with the child. They play together, they work on speech, that she has been present during the time of the surgeries he's had to correct his tongue tie and lip tie situation in this matter. There's been little, if any, testimony from plaintiff or from his guardian in this matter about, again, love, affection, and emotional ties existing. Of course, not disputing those. It's just there's not been any testimony. But when the court looks at it, it looks like this factor does weigh slightly in favor of the defendant mother. Next factor is the capacity and disposition of the parties involved to give the child love, affection, guidance, and continuation in the education, raising the child in a particular religion or creed. There's been no testimony about religious involvement. The court will note that the defendant has testified about, again, working with the child with the speech therapy, working with him and, again, colors as well as different things that would be educational. As she said, this Louis, this educational TV, that she talked about doing, presumably reading books with the child. As a result, the court does note that she has provided those educational involvement with the child. The testimony from the guardian does not address any of these factors relating to the child, so the court will find that this factor does, again, slightly favor the defendant mother. Next factor is the capacity and disposition of the parties involved to provide the child with food, clothing, medical care, and other remedial care recognized in place of medical care and other material needs. In this matter, the court will note that capacity and disposition are two different things. Capacity is that you have the ability to do that. The court notes in questioning of the guardian that the plaintiff does have income of just over $4,900 per month. That is actually $4,948 per month. The plaintiff is working and making $18 per hour. And the child is on Medicaid. That her monthly income is $3,096, so significantly less than the income of the plaintiff. But notwithstanding that she's been the one responsible since the separation of the parties for, again, maintaining and providing the material needs to the child. She said that since that time, the plaintiff did buy diapers once, he bought shoes and some other issues, she said, or other things for the house for the child, but those were limited, again, sounds like on only a few occasions has he contributed, and he's not contributed anything financially, notwithstanding his ability to do so. As a result, the court will find that this factor does favor the defendant mother. Next factor is the length of time the child has lived in a stable, satisfactory environment and the desirability of maintaining continuity. The court will note that the child has been in the mother's care since the separation, that it does appear to be stable. There's been no testimony that's not satisfactory. The court will note that it is going to change, as she said that her partner is buying a home in Albion and they will be moving to that. So that will cause some disruption, but notwithstanding that, it does appear that she has, again, that stable environment, notwithstanding the fact that the home is going to change. The court will find, again, there's a slight advantage to the defendant concerning this factor. Next factor is the permanency of the family unit, existing or proposed custodial home or homes. It doesn't appear from the testimony that there's any anticipated change in the family unit that would have an impact upon the child, so the court is not going to consider that in favor of either party. Next factor is the moral fitness of the parties. There's been no testimony about either party not being morally fit, and as a result, the court will find that that factor weighs equally as to both parties. Next factor is the mental and physical health of the parties involved, as stated by the guardian, that the plaintiff does have some short-term memory loss, some long-term memory loss. It appears that he's getting better, and he also has lost his license because of losing vision in his left eye, and the court is taking this into consideration. There's been no testimony about any disabilities, infirmities of the defendant, so the court will find that this factor does favor the defendant mother. Next factor is the homeschool and community record of the child. The child has only some brief school record, and that is the daycare. Has no really community record at the child's age, but he does have some home record in this matter, and that exists in the defendant's home. So the court will, again, weigh that slightly in her favor. Next factor is the reasonable preference of the child. Court considers him to be a sufficient age to express a preference. The child is 1. Court doesn't deem him to be a sufficient age to express a preference, and as a result, the court did not interview the child. Next factor is the willingness and ability of each of the parents to facilitate and encourage a close continued parent-child relationship between the child and the other parent. In this case, it does appear that the defendant has cooperated with the plaintiff and are making provisions for him to have time with the child. And he stated, she testified about the time at Christmas when she contacted him to give him time with the child. She'd also been testimony, which was affirmed by the guardian, that she has in fact provided the alternating weekend parenting time, as well as sometimes multiple weeks in a row, etc. So the court will find that this factor doesn't favor either party. Next factor is domestic violence. There's been no testimony about that, so the court will not consider that factor. When the court looks at all the factors under the Child Custody Act and the best interest, court does believe that it does demonstrate that it is in the best interest of the minor child that the child remain in the custody of the defendant mother. And I'm saying that in view of the fact that, again, the burden of proof to change that established custodial environment is clear and convincing evidence, which has not been demonstrated, but in fact, the evidence has shown just the opposite, that it is clear and convincing that the child should remain in her care in this particular case. With that, the court then will address issues of parenting time. And parenting time factors are identified in Michigan Compiled Law 722.27A. And the it is presumed that the best interest of the child to have a strong relationship with both parties. And the court has to, pursuant to case law in this matter, has to consider the following factors. First factor is any special circumstances or needs of the child. The court would only state that the only special circumstances or needs are the surgery that the child's having and may have to have in May of this year. Whether the child is a child that's nursing, there's been no testimony about that, so the court will disregard that. Next factor is the likelihood of abuse or neglect of a child during parenting time. There's been no testimony about that. Next, the likelihood of abuse of a parent during the exercise of parenting time. There's been no testimony about that either. Next factor is the inconvenience or burdensome impact of travel on the child. Apparently, that's not a problem, as the parties have, again, been able to facilitate that easy enough. It may be a little bit more difficult if and when the defendant moves. Next factor is whether a parent reasonably expected to exercise ordered parenting time. It looks like that the plaintiff has been quite regular at exercising his parenting time. And so the court would find that when there is ordered parenting time, that in fact he would do that. Next factor is whether a parent frequently failed to exercise parenting time. The court would not find that from the testimony. Next factor is threatened or actual detention of the child. And the court would note there's been no testimony about that in this particular case. And then next, any other relevant factors, and the court has went through the relevant factors under the best interest of the child test. In this matter, the court notes that, again, the child has a routine, has been developed a routine, and the court notes that that routine has provided the plaintiff with the alternating weekend parenting time and, again, some of the holiday as well. So what the court is going to do is the court is going to continue that. I will tell you, and I'll mention to you both, that when I order a particular parenting time, that's not to the exclusion of others. The language of the judgment would provide that the plaintiff is entitled to parenting time in all times and places to which the parties may mutually agree. So if the parties mutually agree, you can vary from the schedule that the court's going to impose. The only schedule the court's imposing is if you can agree. If you can't agree, then you go with the schedule the court's imposing. And I would state that the plaintiff has, indeed, depending upon change in circumstances, has every right to repetition the court in the future to change parenting time if they meet the burden to do so. So that can be changed in the future as things proceed and as things develop in this particular case. But what the court will do is the court will grant parenting time to the plaintiff, continue the alternating weekends from Friday at 6 to Sunday at 6. The court will go through and add, which hadn't been added, but it didn't seem to be a problem, is the court will add alternating holidays pursuant to the front of the court schedule. There's a standard parenting time schedule that provides for alternating legal holidays and Christmas and all of those in there. Court would provide the defendant with 2 non-consecutive weeks in the summer, with, again, providing 30 days notice of the taking of those particular weeks. Again, if in fact the plaintiff doesn't provide 30 days, but contacts the defendant, says, hey, I'd like to do this week and it's 2 weeks away. If they agree, that's fine. But if in fact they don't agree, then he has to comply with and give her the 30 days notice in the summer to get those particular 2 non-consecutive weeks. That will be the ordered parenting time. The court will note that the court will grant and order that the plaintiff pay child support. And I'll take into account the the plaintiff's income of $4,948 per month and the plaintiff's income of $3,096 per month. And that will be calculated pursuant to the Michigan child support formula in this matter. And I'll have to tell you, Sean, because you are representing your brother, you're going to have to prepare the proposed judgment in this matter, as well as the uniform child support order and the judgment information form. Those three forms have to be prepared and submitted to the front of the court for approval. And then after the front of the court approves it, you submit that to the court at that particular time. I know you're going to say, well, I don't know how to do the support calculation of the orders. There are services available such as michiganlegalhelp.org. And if you get on their site, they'll take you, you'll say in there, preparing a judgment, uniform child support order, judgment information form, and they have all the forms right online, so you can do that. And they would have, under the child support, what they do is, all you have to do at that one is you get into the support formula and you'll plug in the incomes, which I've just stated to you. And what it'll do is it'll kick out the amount that is required to be paid pursuant to that particular formula. And then you just plug that number into the uniform child support order. There's also a number you plug into as it relates to uninsured healthcare expenses, and you would put that number in there as well. So all those forms are available and easy to fill in, but it might take you a little bit of time to get that ready and get it done, because not being familiar with it, but it is a relatively easy process. And again, then you submit those to the front of the court for their approval. And then after they've approved it, you submit it to the court. Should you get an objection, I'll tell you first, front of the court's running behind. It takes about a month to get those approved. So when you submit them, it's going to take you about a month to hear back whether it's objected. If they object to it, then all you have to do is correct the objection, not the entire thing, and then resubmit it at that particular point. And it's not unusual when you have impropers that the person has to submit it multiple times, and they do get objections because, quite frankly, people don't know how to fill these out. So it does sometimes require that they resubmit those as well. And Sean, I'll tell you that this matter will remain up on YouTube for 30 days. So if you need to go back and listen to this again as to what you have to do or submit, you can go back and again, replay that and figure out what you have to do, or figure out the incomes that the courts use, et cetera. Likewise, Ms. Gilman, you can do the same thing if you want to go to that. With that, Sean, I'll ask you, is there anything else you believe that the court has failed to address or needs to address before we conclude this hearing?
I don't think so, Your Honor.
Okay. Ms. Gilman, is there anything you believe the court has failed to address or needs to address before we conclude?
No, Your Honor.
Okay. Well, I want to thank both of you. It's, I think, based on what I heard, that everybody is looking at what's best in Barrett's, in his interest in this matter, which can only assist him as he gets older and older, that the two of you are working for his best interest and trying to do what's best for him. And I'll let you know too, that in that instance, when you're trying to do, sometimes things will change. As I said, sometimes the parenting time needs to change. Sometimes, children need more time with a parent than what they've had. And hopefully you'd be able to discuss that and work on that and get that concluded without having to petition the court. I will state, if you're not able to, you always have every opportunity to bring the matter back before the court by filing a motion seeking the court to modify the judgment or something in some way. So I wish you all the best. I hope everything works out for you. And the court will conclude this matter at 9:36 a.m. You're free to go. Have a wonderful day.
Thank you.
Your
You
Honor.
too.